You have the right to represent yourself. But what I will tell you is that Miss Underwood is the bane of most prosecutors' existence because she's a little pit bull and she doesn't put up with a lot of guff from them, and she's a tough defense attorney. So you may not like what she says, but what else is she supposed to do?
You was given false information.
That you were trying to explain the law to me. So if you do not want her as your attorney, I will remove her as your attorney.
I want her as my attorney.
Leroy or Leroy?
Leroy.
Yep, okay, I like Leroy. File number 23-21665FH. I have Brenda Underwood, P41009, appearing on behalf of the defendant, and I have Dan Gumto, but state your full name and your P number, please.
Your Honor, Nicholas Sears on behalf of people. Nicholas Andrew Sears. I am appearing under Michigan Court Rule 8.120, I believe, which is the observation while waiting for my bar results.
Okay, very good. All right, you had your hand up?
Yes, I fired her due to misrepresentation.
When did you fire her?
Over 2 weeks ago.
Was that in front of me?
No, that was in her office but the reason I fired her.
Well, do you have another attorney?
I will represent myself.
You're gonna represent yourself.
Yes.
You know, there's a very famous quote about representing yourself. Do you understand that?
Yes.
That, you know, do you have a law degree?
I don't need a law
Do you have a college degree?
I don't need a law degree.
Do you graduate from high school?
I don't need that either.
You don't need that to represent yourself? Okay, do you have access to, okay, so.
I have evidence that shows that the description did not match. And
well, I'm not gonna get into that yet. So you're asking me today to remove Miss Underwood as your attorney?
Yes, yes,
and you wanna represent yourself?
If I
do you understand that even when I have court cases, I hire an attorney to represent me?
Well, I can't trust anybody in this system in this area because they all seem to be working together. This case should have been resolved a long time ago during the appeal the first time. She should have objected when the claim was made that I matched that description 100%.
Okay, so Mr. Reamer, part of what you're saying shows to me that you don't quite understand how the court procedures work, okay? So your attorney has an obligation to ethically represent you. And so before I would have clients come to me and say, I want you to file this and I want you to file that. And I would say, there's no basis for that. And I don't file frivolous motions, or I would say to them, they have probable cause or whatever. So if you want to represent yourself, you can do that at your own risk. You have the right to represent yourself. But what I will tell you is that Miss Underwood is the bane of most prosecutors' existence because she's a little pit bull and she doesn't put up with a lot of guff from them, and she's a tough defense attorney. So you may not like what she says, but I feel like she's always honest. So that being said, if you want to proceed and represent yourself, you can. But you understand you're going to have to file written motions. You're going to have to follow the court rules.
This is the trial, right?
No, it's a pre-trial.
How is this not the trial? I was told this is going to be the trial. I'm supposed to be facing it. I'm supposed to be sitting here with a jury today.
No, you're not.
Yes,
you're Mr. Raymer. I scheduled jury trials, and I haven't scheduled you a jury trial.
Yes, I was.
Yeah. Oh, wait. You're the one that didn't show for the pre-trial. That's why. Is that why?
Your Honor, if I could speak for a second, I think the first thing we need to do.
I'm sorry.
The bench warrant.
Yes. So, Mr. Raymer, you failed. Yeah, he failed to appear for the pretrial conference.
That's correct.
All right. So everybody stop talking for a minute. So, Ms. Underwood, thank you for reminding me of that. Mr. Raymer, you had a final pretrial conference on December 11th, and we gave you a notice of hearing, and you failed to appear for that pretrial. And because you failed to appear for that pretrial, I canceled the jury trial because it cost me a lot of money to have a jury here. And so if you're not here for the final pretrial, I'm not going to trial until I get you here. So I actually issued a bench warrant for your arrest for failure to appear for the pretrial. Do you understand that? So Ms. Underwood's now asking for me to set aside that bench warrant. Is that what you said?
Thank you, Your Honor. He did demonstrate to the court that he can show up by showing up this morning.
Okay. So Mr. Raymer, so Ms. Underwood's asking me for me to set aside the bench warrant for your failure to appear on December 11th. Do you understand that? Speak.
Yes, ma'am.
All right, and Mr. Sears, any objection to me setting aside the bench warrant since he has it today?
No, Your Honor.
All right, so Mr. Raymer, I will quash that bench warrant, and I'm sorry, I didn't look back to see that this was the original trial date. So that's my procedure. If people don't show up for a pretrial, I set the jury trial as the pretrial, okay? Do you understand that? So that's why
Yes or
there's no
no,
jury.
Yes or no?
I did answer, ma'am.
So we're recording, so we have to hear you, so you have to speak up really loud, okay?
I said yes, ma'am.
Louder.
Yes, ma'am.
Okay, so Mr. Raymer, all right. So Ms. Underwood and Mr. Sears, this is a date and time set for pretrial. Mr. Raymer, I have your attorneys did file all the paperwork. Ms. Underwood, do you want to speak to Mr. Raymer for a moment?
Your Honor, I'm not sure that would do any good.
Okay. So
If
Mr.
Mr. Raymer would like to speak to me, I'm more than happy to speak to Mr. Raymer at this point.
So I'm gonna quash the bench warrant. Mr. Raymer, if you want to sit down and talk with Ms. Underwood and see if you can meet a common ground, I would highly recommend that. You know, if you want to take 5 minutes or 10 minutes and talk to her, you can do that.
She's not been representing me appropriately.
All right, so do you understand you don't get another public defender?
Well, I fired her and I talked to this man. Are you Mr. Glacier?
No, that's Mr. Glazer.
Who was it that was in the office with us?
That was
That
me.
was Mr. Malero.
Okay, Mr. Malero and her, why was he in the office when?
'Cause he's-
In the,
All right, so Mr. Raymer, if you are firing Miss Underwood, or I can grant that, but I don't have the ability to appoint another public defender to represent you.
no,
They are a
I-
separate entity.
If I can't get somebody to represent me that's doing the job appropriately, then I will represent myself. Because I can prove that I was not that person that they're claiming.
That's what a jury trial's for.
Yeah, and when it comes to the jury trial, then I will take care of it there. But I don't need somebody that's not gonna represent me appropriately.
Okay, well, I really doubt that she isn't appropriately representing you, but, so Mr. Glazer and Mr. Malaro, he's asking for me to, he's asking to fire Miss Underwood, so,
If I may, Your Honor.
yes,
Your Honor, I vetted Mr. Raymer's claims about Ms. Underwood's representation. My understanding, she conducted a preliminary examination. She also filed a motion to dismiss, I believe, that was heard and ruled on by this court. I've not determined that she's done anything that did not require, or that was not required of her. I denied Mr. Raymer's request to appoint a new attorney. For one of the reasons was that a trial date was imminent and it would be almost impossible for any attorney to get up to speed. Ms. Underwood is clearly ready to go to trial in this case. I think, as the court, I think, is aware, Mr. Raymer just doesn't like what he hears. So that is the reason I denied his request to have another attorney appointed in this manner, because Ms. Underwood's doing everything she can do on his behalf.
so Mr. Raymer, I guess I would ask, she held a preliminary exam, which is what you do to dispute the charges, and the judge ruled, whoever heard this, that there was probable cause and bound you over, right? Yes,
Yes, Your Honor.
and then she filed a motion to dismiss, is that correct?
Yes, Your Honor.
And I denied that.
Yeah, because you was.
What else is she supposed to do?
You was given false information. All she had to do is object and let it be known that I did not match the description of the person.
That's for a jury to decide.
No, that's for the.
Okay, well, I'm glad that you were trying to explain the law to me. So if you do not want her as your attorney, I will remove her
Yes, I
as your
do not want
attorney.
her as my attorney.
All right, so Ms. Underwood, you are relieved of your duties. So Mr. Raymer, you can either hire an attorney or proceed as you are. So I will get another jury trial date. Mr. Raymer, you will need to file with the court jury instructions and voir dire questions. And those are gonna need to be filed by a certain date.
And how do I go about doing that?
I can't tell you because I can't give legal advice. That's why you had an attorney. So you're gonna have to figure that out on your own.
Okay, well.
I can't give you legal advice as a judge.
That's all right,
That's what Miss Underwood was for.
but she wasn't doing her job.
She did do her job.
No, she
But-
failed,
I'm not gonna argue with Mr. Raymer. So Miss Adams, I'm looking for a trial date.
First available is April 22nd at 9 AM.
Does that work for you, Mr. Sears?
Your Honor, that does work for the people.
All right, does that work for you? Okay, so I'm gonna set trial for April 22nd of 2025 at 9 AM. So was there a plea offer made in this file, Mr. Sears?
Your Honor, yes, there was. It looks like the final plea offer provided from my office was 2 counts of an attempted RMO.
All right, so Mr. Raymer, do you understand the plea offer was to plead to 2 misdemeanors?
Yeah, sure.
Okay, so those are 1-year misdemeanors, so it'd be 2 1-year misdemeanors in lieu of the 5-year felony, because you have, well, 4-year felony, police officer assaulting and resisting causing injury, and you have 2 2-year felonies for police officer assaulting, resisting, and obstructing, and 1 misdemeanor for disorderly person. Are you sure you do not want to proceed with counsel?
I would prefer to have counsel, but I don't want her representing me.
Okay, well, that's your choice, but your other option is to hire someone. Thank you. All right, have a seat back there and we will get you a copy of your pre-trial notice. Over to, in the matter of the people of the state of Michigan versus Shane Leroy Raymer, file number 23-21665 FH. I have Rhonda Underwood appearing on behalf of Mr. Raymer, and I have Amanda Wagner appearing on behalf of the people. So this is the date and time scheduled for a motion to quash the felony information and a motion to dismiss. Ms. Underwood, you may proceed. You can sit down, Mr. Raymer.
Thank you, Your Honor. Your Honor, Rhonda Underwood for Mr. Raymer this morning. My client Shane Leroy Raymer was charged, Your Honor, on October 3rd with police officer assaulting, resisting, and obstructing, causing injury, and 2 counts of police officer assaulting, resisting, and obstructing, and 1 count of disorderly conduct. On December 20th, a preliminary examination was held and the defendant was bound over as charged. The prosecutor at preliminary examination, we believe, failed to establish the following elements. A defendant has the right to resist an unlawful arrest, Your Honor, via People v. Moreno. In the case of Bauer, the defendant is arrested or detained at the moment when he is being handcuffed. This arrest was done without a warrant. A warrantless arrest violates the 4th Amendment if there is no recognized exception. We don't believe any exceptions apply here, Your Honor. The closest exception that people have is a misdemeanor committed in their presence. However, the defendant's conduct before he's taken into custody doesn't rise to the level of disorderly person. The defendant relies on People v. Gagnon, which states disorderly conduct, disturbing the peace provision, requires a finding that an accused, while intoxicated, directly endangered the safety of another person or personal property. In this, defendant also relies on People v. Murwadzaki, where people caught under very similar circumstances asked for identification in the store prior to arrest. What happened in this case, Your Honor, is police responded to a call of someone in the street. They came, they saw Mr. Raymer. Mr. Raymer was in front of his house. He was having some trouble with his bike. And the officer asked Mr. Raymer, then asked or I don't, the officer thought he asked him to fix his bike. I think Mr. Raymer meant trying to fix his bike.
He asked me what I was.
All right, we're not testifying, so you can whisper in her ear, but you can't.
Okay. At any rate, Your Honor, at that time, it's our position that Mr. Raymer had not committed a crime. He had not committed a crime. If he threw the bike in frustration, it was his bike. Mr. Raymer.
I'm just trying to help.
But it's our position that a crime up to that point had not taken place. At that point, the officer tried to detain Mr. Raymer and asked for his identification. Mr. Raymer believed he was within his rights not to provide that, Your Honor, and just wanted to go back to his house. He was not approaching the officer. He was going back to his house. He was not in any way trying to interact with the officer. At that point, the officer tried to detain Mr. Raymer and put him in handcuffs, and that is when I think what is perceived as resisting took place, Your Honor. But it took place with no prior crime that the officer observed.
Okay. All right. Miss Wagner.
Your Honor, so that I don't waste any of your time, did you have an opportunity to review the response that I filed?
We did not receive one.
Oh, okay. I sent it yesterday morning.
If you send it, it's not filed. It has to be filed.
We did file it.
Nope. I just
Okay.
got it in my hand.
Okay. Well, that's good to know.
And yesterday I wasn't in the office. I was at a conference. So
Okay.
Neither was I.
did you receive it?
Yesterday morning.
Okay.
So I got it this morning like that.
I
Okay.
didn't know you were out of the office.
Go ahead, Miss Wagner.
So Your Honor, Ms. Underwood's recitation of the facts of this case and what was established at the preliminary exam just completely belied the evidence that was presented at the exam. And it leaves a lot of facts out. So when Sergeant Adams responded that day, that was the second call that dispatch had received from concerned citizens who were calling specifically about this subject, who was later identified as Shane Raymer. He wasn't just someone in the street. The calls that came in indicated that there was someone in the street who was screaming, cursing, throwing a bike, kicking a bike, being a disorderly person in the street. When Sergeant Adams arrived, a child immediately pointed out Mr. Raymer. Sergeant Adams was in his patrol car. I don't know for exactly how long, but long enough to observe Mr. Raymer screaming, shouting obscenities, kicking his bike, throwing his bike. Of course, the officer didn't know at that time that it was Mr. Raymer's bike, but nonetheless, Sergeant Adams testified that he heard Mr. Raymer screaming obscenities before he ever exited his patrol car. When he did exit the patrol car, and this was established through his body camera that we played at preliminary exam and through his testimony, it shows Sergeant Adams walking up to Mr. Raymer, and I think the first thing that he asked Mr. Raymer is, "Hey, what's going on? Hey man, what's happening?" Very calm, non-provoking demeanor, trying to find out what's going on. And Mr. Raymer is immediately confrontational and aggressive. And for Ms. Underwood to say—
Mr. Raymer, you need to be quiet. Thank you.
For Ms. Underwood to say that Mr. Raymer was just trying to go back in his home, I mean, that could not be further from the truth. That could not be further from what the body cam showed. And we played that at the preliminary exam. It showed him advancing several times towards Sergeant Adams. It can be heard on the body cam where Sergeant Adams says, "Hey, don't come at me." Mr. Raymer is moving around a lot, advancing toward his parents, advancing back towards Sergeant Adams. All of this was established at the preliminary exam. Likewise, what this comes down to is whether the arrest was lawful, not what the prosecutor charged after the fact. So the arrest is lawful as long as Sergeant Adams at that time had reasonable cause to believe either that a misdemeanor or a crime had been committed or that one was committed in his presence. And that includes misdemeanors and ordinance violations. So whether it's disorderly conduct under the statute that the prosecutor charged, whether it's disturbing the public peace, which is under the City of Adrian ordinance, whether it's public intoxication under the city ordinance, it doesn't matter what we charge later. It matters whether Sergeant Adams had reasonable suspicion that a crime was committed at that time. And all of the facts, including the 2 calls that were made within a short period of time, including the child that immediately pointed Mr. Raymer out as the problem, including Sergeant Adams' own observations of Mr. Raymer and his behavior, his aggression, his screaming obscenities that I won't repeat in this courtroom, including that Sergeant Adams could obviously see that there were people around, children, 2 older individuals who were later identified as Mr. Raymer's parents, who he also was screaming at the 2 of them, telling them not to provide police any information. Sergeant Adams attempted to calm the situation down, and it just resulted in more aggression from Mr. Raymer. Also observed, and it was very clear on the body cam, that Mr. Raymer's speech was incredibly slurred and he was unsteady on his feet. So all of that lent and supported his reasonable suspicion that a crime had been committed and was committed in his presence. The arrest was lawful, and I would ask you to deny defense's motion.
All right, response, Ms. Underwood.
Your Honor, I think at the time, Mr. Raymer was convinced that he was being detained unlawfully. And as such, he had the right to resist that unlawful detention. Mr. Raymer, it's very hard for me to hear or to say what the officer heard before he got out of the car, because that's when body cam starts, Your Honor. And there's those few, that 30 seconds where there's no sound. So I don't know what the officer heard. But Mr. Raymer, I don't think at that point was having a problem. And I think contrary to what Ms. Wagner said, he was going back to his house. He didn't want to interact with the officer.
You need to be quiet. Okay. All right. The reason I say that is we record this so we can have a transcript of it, and we have people talking over each other. We can't hear. All right. So in this case, the defendant, through his counsel, has filed a motion to quash. I've had a chance to review the prosecutor's answer as well as their oral argument, as well as review Ms. Underwood's motion. So it's clear that the police officer believed, based on what he saw, that Mr. Raymer was behaving as a disorderly person who is intoxicated in a public place and who is either endangering directly the safety of another person or property or acting in the manner that causes a public disturbance. Alcohol was found on site. And I would agree with Ms. Wagner that a lawful arrest is not determined by what the prosecutor charged after the fact, but only whether officers had reasonable cause at the time of the arrest that the defendant had committed a misdemeanor offense or ordinance violation. Based on that information, Sergeant Adams would have had a reasonable articulable suspicion that the defendant had committed disorderly conduct and would have been appropriate to take him into custody. And RNOs are charged from that, and that's really up to a jury to determine. So we are set. I'm going to deny your motion to quash, the bind over and dismiss. We are set for trial September 19th at 9 a.m. Mr. Raymer, you are charged with 1 count of RNO causing injury, 2 counts of RNO not causing an injury, so a 4-year to 2-year felonies and a 90-day disorderly. and understand, I don't know the facts of the case. The jury will determine your guilt or innocence. But if you are found guilty, I don't know why they were here. I don't think they were here for you. If you are found guilty, you will be remanded to custody that day. All right. Are we prepared to move to trial? I noticed that voir dire questions are due September 3rd of 24. So Ms. Underwood and Ms. Wagner, I expect you guys to prepare those and discuss them. So we have a full book. Is there anything else we need for trial?
I don't believe so, Your Honor.
No, Your Honor. Thank
All
you.
right, thank you all. Ms. Underwood, moving on to your next case.